Good morning. Good morning. It's great to see everyone today. So for those who don't know me, I'm Leonard Baynes, the Dean of the University of Houston Law Center. I'm now in my 9th year as Dean, and we're really pleased to have this Frankel lecture. We want to welcome the audience here and the audience at home watching on Zoom. And we're very thankful to the Frankel family for the support of this lecture for all the years that they have done. It's been a great way for us to bring leading academics together to discuss really tough and timely issues. So I really look forward to this particular conversation today. But as Dean, one of my roles is to tell you about the school, right? For those who may not necessarily be one of our alums or whatnot. And so one of the things I think about our school, the University of Houston Law Center, is that it's a school where we dare to dream, and we dare to dream big. So you think about the building, this John M. O'Quinn Law Building. It was a decades-long dream, but we and our alumni and our faculty and staff in the university dared to dream for this $93 million state-of-the-art building, designed by a women-owned architectural firm. And the thing about the building is the embodiment of our alums, wherever they are and whoever they are. We have alums who've donated to this building in philanthropy from every region of the country, of every gender, every race, every ethnicity. And so you'll see in this building namings after so many people of different backgrounds, and even classrooms and spaces, so that students can see themselves in the future to say, I want to be like wherever it may be. For example, Carol Dinkins, that seminar room on the first floor. She was the first woman elected partner at a major Texas law firm and worked in the Reagan Justice Department. She dared to dream big. You think of John M. O'Quinn himself. He was a first-generation college student. He was from a single-parent household. His father pumped gas for a living. And he went and became editor-in-chief of our Law Review, graduated the highest grades, won moot court competitions, statewide moot court competitions, and won billion-dollar judgments for his clients, avenging the wrongs that they suffered. You think of Jim Lamont, who the alcoves are named after. His mother kept the letter from his college, the college he applied to, that rejected him because of the color of his skin. He was accepted to UH Law Center, was our first African-American graduate, and became the first African-American equity partner at the Winstead firm, one of our most prominent firms in the city. You think of Tony Bonilla. Tony Bonilla is our first Hispanic graduate, 1960. Think about 1960, right? Civil Rights Act, it wasn't even passed yet. Brown versus Board of Education was just a few years. And he went on, became one of the first state representatives of a Hispanic origin from his region, became president of LULAC, and still is practicing in his own firm in 5 offices in the city, in the state. So this is where we are. We dare to dream, and we dare to dream big, and we dare to dream to bring people together, to have these hard conversations, because that's what legal academia does, to have hard conversations on hard issues. And we want to make sure that we continue doing that. We really appreciate the Frankel family for making this happen. So I want to welcome all of you here. And let me just, Professor Morales is going to introduce the panel, but I have to take a point of privilege as dean. So Melissa Murray I met when I was on St. John's faculty 15 years ago, was it? Or so, more than that, maybe a long time ago. And she was a candidate for a position at St. John's. And we recognized her star power then. And I'm glad to see her now. It's not often that you see someone and you see them develop and to grow into this incredible academic, but also someone who's shortlisted for the Supreme Court. It's amazing. It's really wonderful. And so welcome to University of Houston. We really appreciate it. And welcome to others panelists. I had a wonderful conversation with Helen Alvaré last night, who's the Associate Dean at George Mason. And also Reva Siegel had been a colloquium speaker before on Zoom, so it's my first time actually meeting her in person today. So I want to welcome you here, but Professor Morales will go in more detail in the introduction. So thank you so much.
Thank you so much, Dean. I appreciate your point of privilege. It's well earned and deserved. I am so excited to be here today to discuss the jurisprudence of men with you and discuss these difficult issues. We have incredible panelists today, and I think we shouldn't take for granted just how incredible they are. First, our guest of honor, Melissa Murray. She's the Frederick I. Grace Stokes Professor of Law at the NYU Law School of Law, where she also serves as the faculty director of the Birnbaum Women's Leadership Network. Professor Murray, if you watch MSNBC, you know her. She is nationally renowned for her scholarship on family law, constitutional law, and reproductive justice. Her work tackles topics like the regulation of sex and sexuality, marriage and its alternatives, the marriage equality debate, the legal recognition of caregiving, and reproductive rights and justice. She's published in just about all the top law reviews: California, Columbia, Harvard, Michigan, Penn, Virginia, Yale, enough already. She also published Cases on Reproductive Rights and Justice, the first casebook to cover the field. She is also a co-editor of Reproductive Rights and Justice Stories with Reva Siegel and Kate Shaw. In her spare time, Murray is a public intellectual, writing in the New York Times, the Washington Post, Newsweek, and The Nation. She appears regularly on NPR, CNN, ABC, MSNBC, and PBS. Most importantly, Room Rater, a Twitter account that rates the Zoom backgrounds of TV experts on a 10-point scale, consistently rates her Zoom backdrop a 10 out of 10, and granted Professor Murray its highest honor, the 2020 Best Wall Treatment Award. Murray is an honors graduate of the University of Virginia, where she was a Jefferson and Eccles scholar. As a Virginian myself, I can tell you that's a big deal, and the Yale Law School. She was notes editor of the Yale Law Journal. She clerked for now Justice Sonia Sotomayor on the Second Circuit Court of Appeals, and Stefan Underhill of the U.S. District Court for the District of Connecticut. So please, let's give a round welcome to Professor Melissa Murray. Professor Reva Siegel is the Nicholas D.B. Katzenbach Professor of Law at the Yale Law School, and frankly, a living legend. Professor Siegel's prolific and path-breaking scholarship draws on legal history to explore questions of law and inequality, and to analyze how courts interact with representative government and popular movements when they interpret the Constitution. Her influence on American legal thought is truly extraordinary. She is one of the most cited constitutional law scholars of her generation. Brian Leiter's Law Reports ranks her the fourth most cited constitutional law scholar in the country, and she is the only woman to appear in the top 20. She, too, has published in countless leading law reviews, Yale, Harvard, Stanford, California, among many others. Professor Siegel was honored in 2012 with the invitation to write the Supreme Court foreword of the Harvard Law Review, I think perhaps the most prestigious honor in all of legal academia. Professor Siegel is a member of the American Philosophical Society, the American Academy of Arts and Sciences, a fellow of the American Society for Legal History, and she serves on the board of advisors of the American Constitution Society and on the General Counsel of the International Society of Public Law. Finally, Professor Siegel is as true blue as you can be, having attended Yale for her undergraduate law and master's degrees, and having served on the Yale Law faculty for most of her career. Last but not least, Helen Alvaré is a leading academic voice on questions of religious liberty and conscience, as well as fetal life. Professor Alvaré is Associate Dean for Academic Affairs and the Robert A. Levy Endowed Chair in Law and Liberty at Antonin Scalia Law School, George Mason University. Her widely cited research focuses on marriage, parenting, non-marital households, and the First Amendment religion clauses. She too has published in leading law reviews, including the Georgetown Law Review, and is the author of a monograph, Religious Freedom After the Sexual Revolution, A Catholic Guide, as well as book chapters appearing in volumes published by Cambridge University Press. Professor Alvaré has served and continues to serve the Catholic Church in various roles. She is currently a member of the Holy See's Dicastery for Laity, Family, and Life at the Vatican, as well as a board member of Catholic Relief Services. Professor Alvaré also works with the Permanent Observer Mission of the Holy See to the United Nations as a speaker and a delegate to various UN conferences concerning women and the family. Professor Alvaré, too, is a public intellectual, publishing in the New York Times, the Washington Post, and the Huffington Post, as well as CNN.com. She serves as a consultant for ABC News on issues related to religious freedom, Catholics, and the Vatican. Professor Alvaré received her law degree from Cornell University and her master's degree in systematic theology from the Catholic University of America. Let's please give a round welcome to all our speakers. So just to give an overview of how things are going to go, we are going to have Professor Melissa Murray speak. We'll have a response by Professor Reva Siegel, and then we'll have Professor Alvaré speak. And there will be rebuttals at various points, which I'm now forgetting as I stand here. But I will figure that out. So without further ado, please welcome Professor Melissa Murray.
Thank you so much for that, Professor Morales, and thank you so much for inviting me to give the Frankel lecture. Many thanks to the Frankel family for supporting this and for supporting the prospect of conversation on difficult issues between academics. I also want to thank my co-panelists, Reva Siegel, with whom I've been in conversation for some time, and Professor Alvaré, whose work, of course, I have referenced in my own. It's a pleasure to be here today to speak with all of you and to be in conversation with you. And finally, many thanks to Professor and Dean Len Baynes, who, again, our relationship goes back many, many years, more than I care to count, and it is such a delight to see you flourish here at the University of Houston, and I will always think of this building as the house that Len built. So. I also want to thank my family. Houston is not new to me. My in-laws live here. My husband was born and raised in Houston, so my mother-in-law and my sister-in-law are here today, and I think that can only suggest my mother-in-law has forgiven me for 2012 when I wrote a paper entitled Marriage as Punishment. It was purely academic, as I reminded her, but again, I understand the implications. Today's lecture is not about marriage or about punishment, but rather is drawn for an essay that I've written for the University of Houston Law Review, in which I argue that the Roberts Court has advanced what I term a jurisprudence of masculinity. That is, a jurisprudence that prioritizes and protects rights that are coded and understood as male, as well as the men who would exercise those rights. In making this argument, I focus on 3 cases decided in October term 2021. Dobbs versus Jackson Women's Health Organization, New York State Rifle and Pistol Association versus Bruin, and Kennedy versus Bremerton School District. Taken together, I argue, these 3 cases are perhaps the starkest incarnation of the Roberts Court's investment in and commitment to this jurisprudence of masculinity. And so by way of road mapping, I am going to first provide a brief description of each of these cases, and then I'm going to consider how these cases and the jurisprudence of masculinity that they reflect have utterly transformed the landscape of constitutional law. And specifically, I argue that the jurisprudence of masculinity enlists the legal landscape for the protection and prioritization of men's rights by reorganizing the public-private divide, recasting the nature of men's and women's bodies, and recharacterizing the relationship between the state, individuals, and rights and regulation. I'll then pivot to consider how the court's commitment to originalism serves a jurisprudence of masculinity by overlooking crucial histories that do not serve the conservative majority's preferred outcomes. And then finally, I'll consider the court's insistence on a demos prudence of women as a corrective for its solicitude for a jurisprudence of masculinity. So first to the cases. The three cases at the core of my inquiry are Dobbs, Bruen, and Kennedy. And as most of you will know, Dobbs was a challenge to Mississippi HB 1510, which prohibited pre-viability abortions at just 15 weeks, in plain contradiction of established Supreme Court precedent in Roe v. Wade and Planned Parenthood v. Casey. In its June 24th decision, the Dobbs majority upheld the challenged Mississippi law in a 6-3 vote, but it then went further, overruling Roe and Casey on the ground that a right to abortion is not explicit in the text of the Constitution and is not deeply rooted in the history and traditions of this country. Now, the fallout from Dobbs has been swift and unrelenting, but the court's disposition of Dobbs and its evisceration of the constitutional right to abortion stands in stark contrast to the way the court has dealt with other cases, particularly Bruen and Kennedy. So let me first talk about Bruen. In Bruen, the court built upon cases like District of Columbia versus Heller and McDonald versus City of Chicago, decided in 2008 and 2010 respectively, to strike down New York State's concealed carry permitting regime on the ground that the Second Amendment not only confers a right to bear arms in the home for purposes of home defense, but also confirms and confers a right to bear arms outside of the home. And in so doing, this decision lays a foundation for individuals to carry firearms in public. Just a few days after Bruen, the court decided Kennedy versus Bremerton School District, a case involving a high school football coach who was disciplined by his employer, the local school board, because he refused to discontinue his practice of praying at the 50-yard line at the conclusion of each high school football game. In Kennedy, in a 6-3 decision that split along familiar ideological lines, a majority of the court agreed that the school district's disciplinary actions violated Coach Kennedy's rights to free exercise of religion and free speech. Together, these three cases exemplify what I call a jurisprudence of masculinity. They reveal the court's strong preference for protecting and vindicating rights that code male, while dismissing and diminishing the prospect of rights that code female. In addition, these cases reveal an understanding of men as besieged and belittled and embattled rights bearers who require and indeed deserve the court's protection and solicitude. Now, to clarify what I mean, I know many of you are likely puzzling over the prospect of male rights versus female rights, and you are likely thinking that, as a general matter, constitutional rights are gender neutral, and that is obviously correct as a theoretical matter. And as we know, women own guns, women pray, women speak. But these empirical facts do not negate the thrust of my argument, which is that in practice, and in more particularly in the court's understanding, certain constitutional rights, like contract rights and property rights, and the Second Amendment right to bear and keep arms, have been relied upon for the consolidation and expansion of patriarchal power, and thus have been understood and socialized as male rights. Much ink has been spilled on this prospect in the context of the First Amendment. Many have noted the degree to which protections for free speech historically have been deployed to sanction men's power, activities, and pleasures, and to silence objecting women and minorities. To this end, free speech principles have been deployed to protect Nazis in Skokie, Illinois, as well as the use of pornography in the home, while silencing women objecting to sexual harassment and sexual assault in workplaces. Similarly, in cases like Citizens United, the court's understanding of free speech coalesces around fora where men predominate and are more likely to be the speakers who are protected. Similarly, the association of the right to abortion with women's rights clearly proceeds from the physiological association of pregnancy with women, as well as from linkages between reproductive rights and freedom and the movement for women's liberation. Now, the coding of these rights as male and females is evident in the court's disposition of these three cases. In Dobbs, the court explicitly associates the abortion right with women. And in Bruen, The right to bear arms is discussed in tones that evince its association with men, patriarchy, and masculinity. For example, in the Bruen oral argument, Justice Alito bemoaned the prospect of what he called ordinary, hardworking, law-abiding people forced to brave an urban hellscape replete with criminals brandishing illegal guns. But who exactly were these ordinary, law-abiding citizens who required a firearm for defense? According to Justice Alito, they were people who work late at night in Manhattan. It might be someone who cleans offices. It might be a doorman at an apartment. It might be a nurse or an orderly. It might be someone who washes dishes. Tellingly, these hardworking commuters of Justice Alito's imagining are mostly men: janitors, doormen, orderlies, hospital workers, and dishwashers. Likewise, in his majority opinion in Bruen, Justice Thomas recounted a history in which Southern states thwarted Black men seeking to exercise their Second Amendment rights, resulting in their vulnerability to a campaign of racialized violence. On his telling, the right to bear arms was not only a crucial indicium of citizenship, its withholding enabled the consolidation of power in a white patriarchal structure. Now, to be sure, Black men were not the only victims of the racial terror that swept the South and the Midwest during Reconstruction and Redemption. Indeed, the Colfax Massacre, which features prominently in Justice Thomas's majority opinion in Bruen and his separate concurrence in 2010's McDonald versus City of Chicago, involved the rape and slaughter of scores of unarmed Black women. Meaningfully, however, when Justice Thomas cites the Colfax Massacre in his effort to enlarge the scope of the Second Amendment and its protections, he mentions only the deaths of unarmed Black men at the hands of white men bent on preserving an antebellum power structure. But the jurisprudence of masculinity goes beyond merely characterizing certain rights as male and prioritizing those rights and rights bearers in the constitutional order. As I argue in the paper, it operates by fundamentally recasting core assumptions in constitutional law in ways that privilege and prioritize men. One of the core assumptions that is completely upended by the court's jurisprudence is the traditional public-private dichotomy that has permeated constitutional theory. Under liberal democratic theory, society is divided into two spheres, the public and the private, each with its own role and activities. The public sphere is the province of the market and the state, regulation, and men. The private sphere, by contrast, is the sphere of the home, the family, the church. It stands apart from the state and the market and often is figured as a haven or sanctuary from the travails of the public sphere and its regulatory ambit. And meaningfully, the public-private divide has traditionally had this gendered cast. The public was the sphere of men, while the private sphere was the realm of women. And indeed, the Supreme Court constitutionalized this in Bradwell versus the state. But the Roberts Court's ascendant jurisprudence of masculinity turns this traditional configuration of the public and private on its ear. Under the logic of the jurisprudence of masculinity, the public-private dichotomy has been reconfigured such that men, and more particularly men's bodies, are deemed improper subjects of state regulation and thus are rendered coextensive with the private sphere. The court's disposition of Kennedy is exemplary of this dynamic. In Kennedy, the court's ruling rests on the view that Coach Kennedy's prayers are fundamentally private conduct because they occur at a time when Kennedy was permitted to engage in activities unrelated to his performance of his role as a public school football coach. Critically, the court's understanding of Kennedy's conduct as private renders the publicly owned school football field where the prayers occurred part of the private sphere, insulated from state regulation for as long as Kennedy is at prayer. On this account, the fact that an individual is engaged in prayer and acting outside of the scope of his public duties transforms the space, regardless of its public ownership, into something akin to a church, private space unsuited to public regulation. Bruin's expansion of the right to keep and bear arms beyond the home and in the public sphere also reconfigures the public-private divide. Under the common law, a man's home was his castle, and he was entitled to defend himself within the boundaries of his home. The court's decision in Bruin expands the boundary of what we know as the home and castle, the private sphere, into public spaces by insisting that the rights bearer is entitled to keep and bear arms in the public sphere, and that public regulation of these spaces and the right to bear arms in them is presumptively unwelcome. By contrast, in overruling Roe and Casey, the Dobbs majority forecloses the promise of privacy once articulated in decisions like Griswold versus Connecticut and its progeny. Unlike Bruin and Kennedy, where the public sphere yields to an expanded private sphere, Dobbs insists on the rescission of women's privacy in favor of an expanded public sphere where the state's regulatory authority is robust. And critically, the jurisprudence of masculinity then goes beyond even this reconfiguration to transmute these public spaces into private spaces and to recharacterize the rights-bearing bodies within and to reconceive their relationship to the state. Specifically, this jurisprudence gives primacy to the male body, recasting it as either a castle or a temple, the living embodiment of these traditionally private institutions. And again, Kennedy is illustrative. In sequestering Kennedy's prayers from public regulation, the court not only transforms the public space of the school football field and Kennedy's employment as a public school official into nominally private conduct, it also makes clear that the privacy to which Kennedy is entitled is incident to his praying body. By the majority's logic, so long as Kennedy is engaged in the sincere act of prayer at a time reserved for his personal pursuits, he's insulated from public regulation. In this regard, the wall between church and state goes beyond merely protecting sacred conduct. It renders Kennedy's body and the space it occupies a literal temple or church, sacred, private, and utterly beyond the aegis of the state. And a similar alchemy is at work in Bruin, where even public spaces like the New York City subway are viewed as an extension of the home and castle when the security and safety of the individual rights bearer is threatened or imagined as threatened. There is no similar solicitude for the rights of women and pregnant persons. And indeed, the impact of Dobbs has been to render the pregnant body coextensive with the public sphere and state regulation. No longer insulated by the prospect of the constitutional privacy that Roe and Casey once offered, the pregnant body is even more obviously an object of public interest and properly subject to state regulation. As such, individuals living in jurisdictions that are inhospitable to reproductive care now must flee the unrelenting publicness of their home jurisdictions in search of privacy that may be available elsewhere for now. Which is to say, they must actively pursue privacy. It is not incident to their persons. For praying or gun-toting men, by contrast, there is no need to take such affirmative steps to secure privacy. Constitutional protections and the privacy interests that underwrite them are coincident to and proceed from the very fact of men's bodies. And in a similar vein, the jurisprudence of masculinity reconceives the state in this project as well, figuring it either as an antagonist thwarting the rights bearer in the exercise of his rights, or as an ally rightfully thwarting the pregnant person in the exercise of hers. And Kennedy and Bruin reflect this characterization of the state as an antagonist. In Kennedy, for example, the majority frames the school board's concern for Coach Kennedy's post-game prayers as hyperbolic and overblown, dismissing the concerns about student coercion and deriding the district's professed Establishment Clause concerns as manufactured and self-imposed. Likewise, in his Bruin concurrence, Justice Alito suggests that an expansive interpretation of the Second Amendment is a necessary corrective to the state's failures to police unlawful gun possession and other criminal threats. And more particularly, Justice Alito, like Justice Gorsuch and Kennedy, suggests that the state's regulatory energy has been misplaced. Rather than policing the threats to the safety of law-abiding citizens, the state has instead focused its regulatory energies on enacting and enforcing gun control laws, like the challenged concealed carry permitting regime. In both cases, the import is obvious. The state is an antagonist, and the rights-bearing man is a beleaguered victim of the state's over-encroachment. In Dobbs, by contrast, the state is figured as an ally in the project of regulating and restricting abortion. In its closing paragraphs, having laid waste to almost 50 years' worth of abortion jurisprudence, the Dobbs majority turns to the legal standard that will govern future challenges to abortion restrictions. According to the majority, because abortion is not considered a fundamental right, rational basis review is the appropriate standard going forward. And as we all know, rational basis review is the standard of review that is perhaps most deferential to the state, with courts reviewing challenged laws with a strong presumption in favor of their validity. As such, after Dobbs, when states proffer their rationales for restricting or prohibiting entirely abortion, federal courts will review these measures generously, secure in the knowledge that the state is an ally in promoting what it terms legitimate public values, like maternal health and respect for the potentiality of life. Now, of course, the states that choose to regulate abortion are not the only iterations of the state in play here. The court itself is an arm of the state. And the court, in its opinion in Dobbs, has done more to facilitate the regulation of abortion than perhaps any other state actor to date. This is all to say that the Roberts Court's jurisprudence of masculinity goes beyond simply crediting the rights of men at the expense of women's rights. It has fundamentally recast the legal landscape to reorder the distinction between the public and the private. It has recharacterized the relationship between bodies, regulation, and space, and it has reconceived the relationship between the court, citizens, and the state itself. To be very clear, the court's fidelity to a jurisprudence of masculinity is neither natural nor inevitable. Rather, it proceeds from the conservative supermajority's commitment to a selective understanding of originalism and originalist methodologies. Now, those who subscribe to originalism, this idea that the Constitution should be interpreted with an eye toward the original public meaning at time one, the framing of the Constitution in 1787, those who subscribe to this interpretive methodology would likely balk at the prospect of a jurisprudence of masculinity. On their telling, the differences in outcome in Dobbs, Bruen, and Kennedy results from the fact that Bruen and Kennedy are vindicating established rights that are clearly enumerated in the text of the Constitution, whereas Dobbs does not have this mooring in the founding. But of course, the founding is only one moment of constitutional significance. The Reconstruction Amendments are equally significant moments of constitutional interpretation and meaning for the project of understanding original intent. And it is the history of Reconstruction that the majority elides in its disposition of Dobbs. The Reconstruction Amendments were drafted and ratified in the wake of the Civil War with an eye toward explicitly grappling with the consequences of enslavement and its vestiges. The 13th Amendment was intended to abolish slavery and to prevent its preservation in other forms, while the 15th Amendment sought to bring newly freed Black men into the political community through the vote. The 14th Amendment was broader still and was consciously intended to grant the attributes of freedom and citizenship to the formerly enslaved, including formerly enslaved women. So what distinguished freedom from enslavement in the minds of those who framed the Reconstruction Amendments? Well, as the records and the debates in Congress over the Reconstruction Amendments explicitly tell us, the Reconstruction Amendment framers noted that not only could the enslaved not control their own labor, they could not transact civil marriages, they had no expectation of family integrity, and their children and family members could be sold away from them at an owner's whim. On this telling, and by the views of those framers, liberty, as articulated in the 14th Amendment, concerned all of the rights of heart and home to which the citizen was obviously entitled and the enslaved obviously lacked. Now, critically, this broad grant of liberty had particular salience for newly freed Black women. It was clearly understood both in congressional debates and in the popular discourse of the time that for enslaved women, freedom and citizenship was not simply about the control of one's labor. It necessarily involved eliminating the prospect of sexual coercion, sexual violence, and the forced reproduction that were endemic to slavery. In her 1861 autobiography, Harriet Jacobs, a former slave who was forced to bear her master's child, made the point delicately. "Slavery is terrible for men," she wrote, "but it is far more terrible for women." This is all to say that the principles of liberty and equality and the underlying concern for the bodily integrity of enslaved men and women infused the debates over the 14th Amendment. Yet it is utterly absent in the Roberts Court's disposition of Dobbs, which is why the Roberts Court's originalism, which plumbs history to find meaning for the rights of men while eliding the history of Reconstruction and its relationship to the founding, the present, and the rights of women, is so puzzling. Though this elision is befuddling for a court ostensibly driven by the demands of text and history, it is not altogether surprising for a court committed to and invested in a jurisprudence of masculinity. Indeed, it is this kind of selective, itinerant originalism that the jurisprudence of masculinity requires. If the Roberts Court has prioritized men and their rights and plumbed the historical records selectively to undergird their prioritization of these efforts, what constitutional avenues are now left for women to vindicate their rights? Having foreclosed the prospect of jurisprudential protection for abortion as a fundamental right or as an indicium of women's equality, the Dobbs majority invites women to seek relief through the political process. As Justice Alito sagely reminds us, women are not without electoral or political power. What does it mean, though, to require women to vindicate their rights through demosprudence rather than jurisprudence? For years, the court's conservatives have insisted that there is something noble and indeed ennobling about convincing one's fellow citizens of the rightness of one's position, of resolving divisive policy debates through democratic deliberation rather than through judicial fiat. That said, it is worth noting that neither the Bruen majority nor the Kennedy majority is particularly concerned about usurping the fraught and divisive questions of gun control and public prayer from democratic processes, depriving the Bruen plaintiffs and Coach Kennedy of the joy and satisfaction of convincing their fellow citizens of their need to publicly carry a gun or engage in public prayer. Indeed, in both cases, the court seems willfully blind to the prospect of democratic engagement and deliberation. After all, New York's concealed carrying permit regime was the product of democratic deliberation and enactment in the state legislature. Likewise, the school district officials that considered the issue of Coach Kennedy's midfield prayers were democratically elected by and represented Bremerton's citizens. Despite these clear indications of democratic engagement on these two fraught questions, the urgent interest in allowing the people to speak is absent in both Bruen and Kennedy, even as it is a leitmotif in Dobbs. Leaving aside the question of whether one's humanity, equality, and bodily integrity ought to be decided by a majority vote, the fact remains that even as the Robert Court encourages women to pursue their rights through the democratic process, its decisions have completely disrupted and distorted the landscape in which such deliberation might occur. From decisions like Rousseau versus Common Cause, which declared partisan gerrymandering beyond the remit of the federal courts, to Shelby County versus Holder, which dismantled the Voting Rights Act's preclearance regime, paving the way for a wave of ever more restrictive and suppressive voting laws, to shadow docket decisions that have allowed unconstitutional, racially gerrymandered voting maps to be used in the recent midterm elections. The Roberts Courts has done more than perhaps any other actor to upend the democratic landscape and to make it harder for citizens to register their preferences at the ballot box. Now, this is likely not coincidental, that the court has consigned the issue of abortion and women's rights to the democratic process at the very moment it is making American democracy less democratic. That is likely the point. When we consider this demosprudence and the prospect of women putting their rights and status as citizens to a majority vote in tandem with the prospect of a jurisprudence of masculinity, which figures men as beleaguered and besieged victims of the state, deserving of both the law's protection and the court's solicitude, the comparison is striking. The court's efforts to consign women's rights to the demos is part and parcel of its efforts to construct and bolster a constitutional and electoral landscape by, for, and about men. Thus, while October term 2021 will always be remembered for the court's evisceration of the constitutional right to abortion, its full impact actually goes well beyond Dobbs. As I have explained, in other cases that have received far less attention, the court has prioritized and privileged male rights, even as it consigns women and their rights to the uncertainties of a distorted democracy. As the court proceeds to October term 2022, new cases will provide new ground for tilling the seeds of this emerging jurisprudence. The new question, of course, is whether this restless and newly constituted court will see fit to continue the work that it has begun, refashioning our constitutional order in the image of men. Thank you.
Okay, so first of all, I want to thank the Frankel family and the Law Review, Dean Baynes, Professor Morales, and Professor Murray for this invitation to comment on her Frankel lecture. I also want to just specifically congratulate the Law Review in its selection of Professor Murray, not only because you've got yourself a rock star here, but because of the tour de force lecture which she's just delivered, which couldn't be more perfectly timed in its historical moment. I attended law school at a time at which there was one tenured woman on the faculty, so it's kind of interesting to imagine that if the court's going to deliver the kind of judgments it's delivering now, that as you're in law school, you have the benefit of reflecting on them with the context that Professor Murray is providing you. So last week, Judge David Count of the Western District of Texas applied the Second Amendment as interpreted by the Supreme Court in Bruin. The question at issue in United States versus Perez-Gallon was whether the government could enforce a domestic violence prohibitor, a federal law enacted in 1994 that prohibits the possession of a firearm by any person who's subject to a restraining order for intimate partner violence. And Second Amendment decisions under Heller before Bruin had held that the domestic violence prohibitor advanced the government's interest in protecting public safety. The presence of a gun in a domestic violence situation increases the risk of homicide by 500%. But applying Bruin's history and tradition method, Judge Count ruled just last week that a law prohibiting a person under court order for partner violence for possessing a gun was unconstitutional. He reasoned, quote, domestic abusers are not new, but until the mid-70s, government intervention, much less removing an individual's firearms because of domestic violence, practically did not exist. The court reasoned that the general societal problem of intimate partner violence has existed since before the founding, but until the 70s, the American legal system barely took formal legal action in response, and for Judge Count, that meant under the history and tradition method, the domestic violence prohibitor of the 1994 Act was unconstitutional because it broke with the historical tradition of inaction. Take that in. I thought it was a case that seemed to speak to the themes of the lecture. So Professor Murray has described Bruin and Dobbs, along with Kennedy, as part of the court's ascendant jurisprudence of masculinity, observing that the court prioritizes explicitly and implicitly men's rights, even as it diminishes and constrains women's rights. And my comment on Professor Murray's lecture has zeroed in, the written form of it zeroes in on the history and tradition method and on originalism as instruments that gender the court's jurisprudence. And we can see the dynamic at work in the Paris-Gallon case. Why did Judge Count, applying Bruin's history and tradition method, strike down the domestic violence prohibitor? Because the judge tied the Constitution's current meaning to past practice. So what's the gender of that judgment? So as I explain in my paper, and I'm now just going to quote from it, originalism is gendered in at least the following simple sense. Originalists would interpret our Constitution in light of lawmaking at the founding. And at Reconstruction, times when men excluded women from lawmaking and saw women as the kind of persons who were to be governed and not fit to engage in self-governance. In this respect, originalism's deeply gendered, and for that matter, raced and classed. It elevates in significance and in weight the decisions, deliberations, and cultural mores of a class of lawmakers who were only a minority of the adult population and saw fit to exclude others from participating in self-governance. The Constitution was democratic for its time, but not by standards of the current day. Most originalists are unconcerned about the methodological bias that I'm identifying here, uncritical of the democratic deficits of the founders' own Constitution and of the ways in which their own interpretive method in turn exacerbates those deficits. Notice that the Paris-Gallon case illustrates the problem here. It's not only that women couldn't vote, and for decades after they could vote were marginalized, it's that even after the period in which women could vote, they were locked out of political power and legal authority, and so that essentially the norms and law of the prior period continued to govern and structure their political opportunities. The common law essentially first authorized and then tacitly sanctioned intimate partner violence. Women did not want this, but they lacked the political power to stop it until very recently. That's the '94 Act. Bruin, or it's now being enforced, is using Article III power to strike down their recent efforts to change the law. An example. So my paper, which is entitled, now I'm choking, How History and Tradition Perpetuate Status, reminds us that we the people rest in part, on past practices of domination, to put it simply. But I'm also focused on the act of perpetuation. Judge Count had choices in the way he interpreted the Bruin decision. I'm not going to take the time here to go into the detail. Just as the Supreme Court justices in the majorities in Bruin and Dobbs had choices in the ways they interpreted the Second Amendment and the 14th Amendment. My paper is showing gendering at work in history and tradition jurisprudence at several layers. First, the conservative justices exacerbate the deficits of the Constitution by killing off dynamic modes of interpretation under the Second Amendment and under the 14th Amendment, and tying the Constitution's current meaning to the law of past eras, which was much more gender hierarchical, in part because of who could participate in its making. Secondly, my paper illustrates that this turn to the past is selective, arising out of an act of identification with the past that is not consistently demonstrated in all of the justices' decisions, but rather results from an instinct to invoke the past to speak for values of the present. I show that in other of the justices' decisions, Justice Thomas and Justice Alito know how to condemn American lawmaking in the past when they judge it to be racist or to display anti-Catholic bias, meaning their deference to the past is not categorical. It is, in fact, contains acts of judgment. For example, in a 2020 decision in Espinoza versus Montana, the court struck down a provision of the Montana Constitution that barred the state from funding religious schools. The court ruled that the provision violated the Free Exercise Clause of the First Amendment. Justice Alito wrote a long concurrence describing nativism and anti-Catholic bias in the 19th century. This is not going to stand. Nativism and anti-Catholic bias in the 19th century, even though the law at issue was actually enacted in the 1970s. Justice Alito wanted America to revisit the past, its past, in light of current values, and learn from the past, with the court's help, to protect individuals from like bias or related kinds in the present. I compare Justice Alito's opinions in Espinoza and in Dobbs to make visible how the turn to the past, in fact, can express a justice's values. In Dobbs, the justices turned to the past to express their values much as Judge Count did when he applied Bruin to strike down the domestic violence prohibitor for gun possession in Paris-Gallon. The justices have employed discretion, first to construct a standard. In a talk of greater length, I would talk to you about how the Glucksberg History and Tradition Standard has been adapted in this case. It was the position of the dissenting justices in the marriage case. Then the justices employ their discretion in the way that they shape the historical record in a past that they call our tradition. I'm now going to be focusing, as my paper does, on the Dobbs decision. In my comment on Professor Murray's paper, I consider some of the ways in which Justice Alito constructed a tradition as another aspect of gendering the record, or the gender of the jurisprudence here. Justice Alito's opinion in Dobbs does not just count statutes in the Dobbs opinion. He rules on whether the statutes were enacted for legitimate reasons, in the process dismissing evidence of nativism and of sexism in the record that would have been clearly unconstitutional today. How did that evidence enter? At the founding and for decades after, the common law allowed abortion until quickening, a woman's perception of fetal movement, approximately week 16 into the 20s, possibly 25, of pregnancy. We can just say roughly there was a standard not unlike the viability standard, but in any event, there was access to abortion in this early period. In the mid-19th century, advocates sought to ban abortion and contraception. They invoked scientific understandings of when life begins, but it was not standing alone. The argument was not sufficient to move Americans to adopt legislation that banned the act. By the 1860s, their tracts couple arguments for protecting unborn life, which they called murder. I'm just putting this out there for you, so there are arguments that of the kind that Justice Alito talks about, with arguments that relate the relative birth rates of immigrants and persons they call Native Americans, and also exhort legislators to enforce wives' marital duties, scoffing at women's interests in suffrage and involuntary motherhood. All of these arguments, legitimate and illegitimate, aligned, and these tracts argue that by prohibiting abortion, advocates argue, Americans could protect unborn life, preserve the ethnic and religious character of the nation, and enforce women's roles. All of the arguments flowing together, all of them all together. Briefs pointed this out, the fusion of legitimate and illegitimate reasons for the statute's enactment. And Justice Alito's decision goes on for some pages interacting with these arguments and sets up an either-or. Are we to believe that the hundreds of lawmakers whose votes were needed to enact those laws were motivated by hostility to Catholics and women? There is ample evidence that the passage of these laws was instead supported by sincere belief that abortion kills a human being. My question, why is the evidence either or? Why not both and? Here we can see Justice Alito constructing a tradition and speaking through the past, what I call in another of my papers, ventriloquizing his sources. In other words, he seeks to view the past as a clean and a pure past, an unethically troubled past, because he wants it to speak the norm he's seeking. If one looks at these sources, and I have, there is a river of gender status reasoning about the criminalization of abortion that Justice Alito simply sweeps under the rug, about what women owe in the performance of sex and in caregiving roles. And it's really head-spinning, the amount of this. It's just ordinary speak and not surprising. This is during the era in which even the Supreme Court was willing to say states could bar women from practicing law, could bar women from voting. So it is not surprising that it is there. It's, we might even say, normal that it was an integral part of the argument. So what are we to say about this record then? I think I'm moved to say something like the following. I fervently wish that Justice Alito cared about revisiting the historical record in Dobbs as he did in Espinoza, the free exercise case in which he was concerned about discrimination against Catholics. In Espinoza, he realized that we should recognize wrongdoing in the past so that we wouldn't repeat it in the future, and insisted that courts have a special role, an obligation to help the nation recognize and engage in that practice of recognition. So far as I'm concerned, he missed an opportunity to face the question of how to conduct a debate about abortion that doesn't risk imposing some people's beliefs about family roles on others. We see that indifference to gender imposition in Dobbs no less than in Paris Gallon, the domestic violence case on which I began. There was no unanimity about gender roles in the past any more than there is in the present, as Tuesday's election returns demonstrate. Pause and consider that. The use of coercion against poor women of Mississippi or of Texas who have no means to avoid it is just that. Like voters, whether in Michigan or Vermont, I would support a constitution that mandated that the state employ the least restrictive means to protect life first, that engage in a process of recognizing and respecting equality before employing coercion. But we can't even begin to have a conversation of that kind until a court reasons seriously about what it means to respect women's rights and women's lives while protecting unborn life, as this court has not shown itself willing to do in this decision. That is why the conversation Professor Murray has opened is so critical. Thank you.
I want to thank the Houston Law Review and your fine dean for inviting me, and to thank these two heavyweight intellects for engaging on this topic. I'm honored to be here. When thinking about how to spend my 15 minutes, I thought not only of the topic on the table, but also how I might contribute to the common good of civility on a much disputed topic. That means I'm going to address weaknesses on both sides of this question about abortion, and I'm going to stick to the facts out of respect for all the people involved. And regarding my attention to the facts, you may or may not know this, but the law school that I come from, Scalia Law at George Mason, is like 60% PhD empiricists on the faculty. And when you go to present a paper, which is always a sort of death-defying kind of exercise, even as a colleague, they want to know, where's your facts, where's your proof, where's your paper's balanced conclusion that my paper is good on this, but not so great on that, and I need more research. So therefore, more than a few of my interventions today will be of the let's talk about where the facts are type. As an aside, I would just mention regarding Professor Siegel's presentation, and given the heft of her scholarship, I brought this huge, heavy book to Houston to engage with that and just to show it to you. It's a book by a pro-choice Unitarian scholar, Joseph De La Pena, which actually describes and prints out across 1,200 long, hard-to-read pages every law on the subject of abortion in the earlier and later 19th century and 20th century, showing that there is a fuller cultural, legal, and movement record of that period about the law's intention to protect unborn human beings, including wonderful chapters on the opinions of virtually every one of the feminist suffragettes of that period in support of laws to restrict abortion. So I can't recommend this book to you enough for the full historical record. But now my comments specifically on Professor Murray's paper, which end up with the conclusion, no matter what we think about the gun cases in particular, the Dobbs majority was correct that the Constitution does not contain a right to legal abortion. It is not there. States can do it. The Constitution cannot do it for them. I want to begin by observing that both in its law and its culture, America's not a pro-life country. It's also not a pro-choice country. It was a pro-life country, as evidenced by the nearly universal set of state laws protecting unborn lives, from before the 14th Amendment to after, from before women got the right to vote to after. And even today, we feature a very divided populace, among women as well as men. This is not the stuff of which constitutional liberties are made. Whether you're the Dobbs majority and you look at abortion laws they did from the founding of the United States through the 14th Amendment afterwards to the very eve of Roe and even to 2022. Whether you're Professor Murray and you understand the 14th Amendment to assure especially former slaves' right to bodily and family integrity, or whether you're the Dobbs dissenters and you claim the 14th Amendment's liberty guarantee is best understood by looking at the long sweep of the nation's history and new societal understandings. Under any of these tests, it's impossible to conclude that abortion has ever been part of our liberty as the 14th Amendment understood it. It's the opposite of a human being's right to bodily and family integrity, and the whole course of the nation's history and tradition demonstrate the opposite. I want to point out that instead, if you actually look at what people's opinions are, and I'll get to women's opinions in particular too, what Roe and Casey required every state to allow, abortion even through the third trimester, and I'm quoting from Roe's companion case when they said it had to be allowed for health of the mother, which includes all factors, physical, psychological, emotional, familial, or the woman's age. I agree, listen to this nice word, with Professors Murray and Siegel, that we should be very attentive to the possibility of sexism in originalist inquiries into the Constitution, including among the arguments in favor of pro-life laws. Totally agree with that. And in fact, I want to engage Professor Siegel's paper in particular because she goes on about that in ways that I find really good. There were some truly disturbing statements made by pro-life advocates during that period about women. At the same time, we can observe really disturbing statements made by Margaret Sanger, the founder of the nation's largest abortion provider, and Planned Parenthood has recently come to terms with that and apologized to them. I don't think anybody really believes that the pro-life movement or legislators of the 19th, 20th, or 21st century were mostly out to put women in their place, or that the pro-choice leaders, which really didn't arise much until the 20th, early 20th, 21st centuries, really want to have abortion in order so that we have fewer immigrants, people of color, and disabled people. Furthermore, sexist originalism does not at all characterize the Dobbs holding for two reasons. First, it's not originalist in the way Professor Murray in particular and Siegel or the Dobbs dissenters talk about. It's, well, and less so, I should say, Professor Siegel's paper, because we agree that their originalism is a little bit hard to figure out. Why? They not only talk about the laws before the 14th Amendment was ratified, or the original public meaning of the 14th Amendment, as evidenced by states' nearly univocal banning of abortion, in particular in response to the evidence of when conception began. They did not really realize the existence of the ova or the events of fertilization until the 19th century. And then abortion laws moved to jive with science at that point and to protect human life from when they knew it began. Justice Alito discusses that. He discusses the laws in the late 19th century, in the early 20th century, right up to the eve of Roe. He then points out that 26 states at this moment asked him to overturn Roe and Casey. He could have added, if he wanted, taking a look at Alan Guttmacher Institute statistics on the state's efforts, even since Roe, to restrict the effect of its holding or to overthrow it entirely. The Guttmacher Institute, the most renowned pro-choice researcher in the country, points out that there's been almost 1,100 laws passed restricting abortion in every state since Roe, more than 10 times that amount of attempted legislation. Again, not the stuff of which a pattern of understanding about liberty is really made. Second, the majority analysis in Dobbs is not sexist, okay? Because both the 19th and early 20th centuries pro-life laws and later 20th and 21st century laws, all of which Dobbs consulted for purposes of its substantive due process analysis, were provably, overwhelmingly animated by legislators and citizens' conviction that a decent society protects human life from the time you know when it exists. I think, again, take a look at this exhaustive account of all the articles, the laws, the public discussion throughout that period, and I think you'll come to agree. Furthermore, if you look at the laws proposed and the public discussion and the testimony in support of all these things by the pro-life movement today, you'll see that there are laws about fetal pain, fetal heartbeat, the explicit violence and gruesomeness, a word that Justice Ginsburg used to describe partial birth abortion, the gruesomeness of particular abortion methods, and the targeting of disabled children. All of these sound in respect for unborn human bodies, not in any desire to take down women's position in society. What about Professor Murray's argument that Dobbs is sexist because it's part of a pattern of masculinist Supreme Court decisions, and that Dobbs was handed down at the time that gerrymandering and voter suppression is impairing the passage of pro-choice laws? Let's look at the evidence. Professor Murray says gun rights and religious freedom code male. And it's true that women do favor legal limits on guns more than men, but today are increasingly likely to own them and have now surpassed men in gun buying over the last year. And what about Professor Murray's claim that Justice Alito had men in mind when he struck down New York's concealed carry laws and named a litany of folks who might need guns to protect themselves? For the record, I'm frankly in favor of gun control, but I still hold here that with regard to his statement that he was naming the self-defense rights of people who work late, clean offices, are doormen, nurses, orderlies, or dishwashers, unquote. Aside from the reference to doormen, everything else he spoke about has either large numbers or overwhelming numbers of women. The Federal Bureau of Labor Statistics says women are 87% of the nurses he mentioned, 53% of the orderlies he mentioned, 89% of the cleaners he mentioned, and even 24% of dishwashers. And who knows how many women work late at night, right? That could be women. Regarding the frame that religious freedom codes male, Professor Murray focuses on one case from the last term, the Professor Kennedy case, and the Masterpiece Cake decision, but neglects the women in dozens of other Supreme Court cases trying to vindicate their free exercise. In particular, the woman whose case set the standard for the strong judicial protection of First Amendment free exercise rights, Sherbert versus Werner, okay? It not only set the standard for a very high level of free exercise rights when it was passed, but additionally, that case was referenced in 1990 when Justice Scalia took down strong protection for religious freedom in the Smith case, and we had the passage by the left and the right, I think almost a unanimous Congress, signed by President Clinton, of the Religious Freedom Restoration Act. It was a woman's case that set the standard, Sherbert versus Werner, for the strong protection of religious freedom in that piece of legislation. And what about all those women suing not only to allow their children to have a neutral ability funding-wise to enter religious schools as well as state schools, and all those women suing to protect their businesses and their nonprofits with their religious freedom so that they could operate them in consonance with their conscience, okay? And what about the website designer who is seeking the identical freedom as was sought by Jack Phillips in the Masterpiece Cake decision in order to vindicate the exact same right in this term's 303 creative case? Finally, on the religion matter, women practice religion a lot more than men in the United States, and polls show that they continue to value religious freedom more than men as a constitutional right. And does abortion really code female? When over the past 5 decades, all leading pollsters have shown that either women were a little more pro-life than men, or a tiny bit less, or about even. But if you look at 50 years Gallup polling, you can't say that women are more in favor of abortion than men. For the most part, they've been more pro-life. Recently, it's up and down. Women lead every major pro-life organization in the US. When peer-reviewed pro-choice researchers, including the leading one, David Ferguson, has concluded that on average, abortion negatively, psychologically impacts women. When women have outvoted men, and I mean by like 10 million votes in presidential elections, and slightly less than that, but still vastly more than men, in election cycles for a very long time, including explicitly in states like Mississippi and others that have passed pro-life laws, when only tiny percentages of women agree with the holdings of Roe and Casey, when law and economic analyses indicate that legal abortion has let corporations and lawmakers off the hook for accommodating women's fertility and mothering, Finally, is it true the court's handing abortion back to the states now, during a period of claimed gerrymandering and voter suppression, is either in intent or in effect going to lead to more pro-life laws and less pro-choice laws? Well, I've first disputed that abortion code's female, but set that aside. This argument presumes that you can do explicit empirical linking of gerrymandering with pro-life laws or voter suppression, and Professor Murray's paper does not attempt either of those things. And interestingly, while she claims that Kansas it's a model state for people voicing their approval of abortion and getting their voice heard in the public sphere, the Kansas ACLU thinks there's a ton of voter suppression in Kansas. And I would point out states like Illinois, where nobody disagrees it's gerrymandered, has on its books a law protecting abortion right up to the moment of birth. And about voter suppression, interestingly, the claim is that voter suppression would affect people of color. I might add the usual claim is also that it would affect people who are poor. But this would result, if there was voter suppression, frankly, in more pro-choice laws than pro-life laws. Why? People of color have been, until very recently, drastically more pro-life than the majority white population. And now it's about even. Okay? Also, poor people are far more pro-life than people with money. And so if you're suppressing their votes, you're going to end up with more pro-choice laws, not more pro-life laws. Okay? Allow me to conclude with this observation. Professors Murray and Siegel, and also the Dobbs dissenters, attempt to discredit Dobbs as sexist using different methods, by claiming a masculinist bias, by impugning pro-life actors in the later 19th century, and the Dobbs dissenters by assuring us that the majority looked only at the state laws in 1868 and that's it. I've responded to each of these accusations, but I want to point out that every one of these attempts to discredit Dobbs avoids, like the plague, consulting the demos, Americans' actual opinions, as they've expressed them to pollsters, in abortion laws, and in public movements. And it goes against everything the country has done since before 1868 and since in the way of a divided public opinion. Those using Dobbs or discrediting Dobbs usually try and use demos-rousing, right? Rabble-rousing, populist-rousing language. Come on, let's take our rights back. But they have no intention of consulting the wishes of the demos. If these were realized, the situation would look a lot like what the Dobbs majority gave voice to. Different states passing different abortion laws. Instead, Professor Murray and the Dobbs dissenters would give the authority to 5 or more members of the US Supreme Court, like the men who gave us Roe in the first place and who ended up giving us the Casey plurality opinion with Justice O'Connor additionally. Professor Murray, ironically enough, would give us abortion by interpreting the 14th Amendment's protection for bodily integrity and family integrity of vulnerable people to constitutionalize the destruction of some others' bodies and family integrity. And that just seems highly ironic and contrary to me. Last word, I think the meaning of liberty in the 14th Amendment ought to bear at least some relation to what citizens of the United States, at some period in our history, have generally understood as an essential freedom. But the evidence really is clear. Abortion is no such thing. Thank you very much.
So thank you to both Professor Siegel and Professor Alvaré for these comments and for engaging so closely with my work, which I deeply appreciate. Let me just start with this idea that contested issues are the sorts of issues that necessarily are not the stuff, as Professor Alvaré puts it, of which constitutional rights are made. If we take that seriously, I think we would then have to reconsider certainly Bruin, maybe even Coach Kennedy and Kennedy versus Bremerton School District. There is considerable debate over gun control, as I noted in my remarks. There's considerable debate over the prospect of school prayer, not the least of which because we live in a society that is religiously plural and was purposely crafted to be so. And so again, if the question is whether or not issues are divided and there's public debate over them, whether that can tell us what a fundamental right looks like, then I think the question is not simply one that is limited to the issue of abortion and reproductive rights, but encompasses broadly some of these rights that 5 members of this court have already told us are fundamental rights. And so perhaps we should think about that. To the extent that I, alongside the Dobbs dissenters, would give the authority to determine what is a fundamental right and what should be determined in the demos to 5 unelected judges. We're already there. So this is not a question of what I would do. It is a question of where we are. We already have 5 unelected judges who have told us what our rights look like and what correctives we can take upon ourselves to deal with it. But let me get into both of these papers, just laying that to the side. Professor Alvaré takes issue with my characterization of certain rights as male or female. So I just want to dispatch with that. I thought I had dealt with it in the presentation, but let me reiterate. It is true that women own guns, and indeed there are a growing constituency among gun owners who are women, and including black women. It is also the case that our constitutional law is liberally peppered with litigants who pressed First Amendment claims who were women, like Adele Sherbert, whom Professor Alvaré referenced. But again, the fact that there are women who own guns, or women who pray, or women who speak, does not undermine what I am saying, does not negate the view that this court, both historically and presently, views certain rights as super rights, and those super rights often accord with a masculinist understanding of how the right is socialized. So this inquiry is not necessarily an issue of empirical facts, and I don't dispute those facts. It is a question of socialization, it is a question of history, and it is a question of the way in which these rights have been understood to be used to consolidate power in a patriarchal order. And Professor Alvaré does not respond to that, and indeed she cannot, because it's there on the face of these cases. Justice Thomas concedes as much in his majority opinion in Bruin, where he recites the long history of withholding Second Amendment rights from black men in the name of preserving white patriarchy. Now, Professor Alvaré also mentions and maintains that my essay and the Dobbs dissent are of a piece, that in condemning the lawlessness of the majority's decision in Dobbs, we've effectively sidelined the voices of those who, across the sweep of time, have objected to the prospect of abortion rights. Now, again, unlike the question of the empirics of gun ownership, I actually do think this question of the history and public response to that history is germane to the inquiry. So I want to take Professor Alvaré up on her invitation to consider that broad sweep of history and the objections to abortion that have over time been raised. It is worth remembering that the Dobbs court is not the only court that considered abortion, and in doing so, canvassed the sweep of history. The Roe court did so as well, and came out with a very different outcome, which is to say that history is not necessarily empirical. It is, as Professor Siegel reminds us, contested and contestable. This is something to which Justice Thomas admits as well in his majority opinion in Bruin, where he tells us that not all constitutional history is created equal. I would love to know how he determines what constitutional history to weigh and what constitutional history he would prefer to discard. I imagine I know the methodology, but I would like it articulated. Separately, it is worth noting that even as the Roe court arrived at a long history of abortion regulation and came to a different outcome, the Dobbs court does the same thing, arriving at its own conclusion that the history does not support a fundamental right to abortion. But interestingly, it spends very little time discussing the history in which women in our country had broad discretion to terminate a pregnancy in the period before what was known as quickening, the period usually marked at 16 to 24 weeks of pregnancy when the woman could detect fetal movement. This was discussed at length in Roe. It is painfully absent in the discussion of the history in Dobbs. More importantly, even after the physician-led campaign to criminalize abortion at all stages was initiated in the mid-19th century, the public continued to resist the enforcement of those laws on the ground that they still hewed to the older common law model that allowed a woman at her discretion to terminate a pregnancy before quickening. Now, this was not unknown to Justice Alito and the Dobbs Court. The Organization of American Historians mentioned this history at length in its brief before the court. It also noted that many of the 19th century prohibitions on abortion were not necessarily about promoting or protecting fetal life, but rather were explicitly about discouraging illicit sex and bolstering marriage and the sex roles that marriage prescribed in order to shore up the social order in which men were providers and women were homebound dependents. Now, why is that not mentioned in the court's disposition of Dobbs? Perhaps it is because, as Professor Siegel suggests, because it undermines the majority's view that there has always been this public opposition to abortion, even though the history makes clear that this is not as obvious or as unnuanced as the majority would suggest. But it is necessary for the majority's project, because if you are to overrule 50 years' worth of precedent, you need to make sure the history looks uncomplicated. And Justice Alito has been a master at that. In addition to this history regarding the common law tradition, the OAH brief, like Professor Siegel's remarks, makes clear that the effort to criminalize abortion in the 1860s was shot through with anti-immigrant fervor and undergirded by sex-based stereotypes that insisted on women staying in their lanes as wives and mothers. So I appreciate Professor Alvaré's willingness to engage on these points. It is worth noting that when these criminal laws were being enacted, they were in response to not only women resisting and chafing at these traditional sex roles, but that they were actively moving into other parts of public life, trying to get an education, working at jobs, and recognizing that control over their reproductive capacity was absolutely imperative to be able to do so. The response, the curtailment of reproductive freedom, was not simply about promoting fetal life, but rather about curtailing that shift from the private sphere to the public. In much the same way, the reorganization of the private and public spheres occurs in Kennedy and Bruen. Now, Professor Siegel's remarks, which again begin so wonderfully with the recitation of Judge Count's opinions in Paris Gillen, which I will now include in my own paper. It was decided after the deadline for my paper, so I know Kelsey is in the back dying inside when she hears that I'm going to be changing this. But it is, again, I think, as she points out, a cogent depiction of the failures of this originalist history in Bruen, and indeed the way in which this originalism is in service of a jurisprudence of masculinity. As she cogently depicts, this court is happy to focus on history, and indeed to use history to correct the missteps of our past, but only when doing so is consistent with its preferred ideological outcome. It is why Justice Thomas waxes lyrical about Reconstruction and redemption in Bruen, while remaining silent to the congressional record and the statements of the Reconstruction Congress about the broad reach of the 14th Amendment's liberty interest and the desire to infuse the 14th Amendment with the principles enshrined in the Declaration of Independence and the 9th Amendment. With that in mind, let me turn to Professor Siegel's critique of my own argument, which I think is apt. As I write in my essay, originalism knows no gender and does not necessarily demand the conservative outcomes it serves. In this regard, I appear to subscribe to a view of originalism that, if properly practiced, yields objective rather than determinative outcomes. As Professor Siegel notes, this is probably naive on my part, probably too generous by half. And indeed, it neglects the degree to which a method of constitutional interpretation that is explicitly rooted in a period of democratic deficit is not simply about restraining judicial discretion. It is actively about silencing the voices of the people when it is actually reflected in jurisprudence. And Professor Siegel shows this in her comments and in her discussion of Justice Alito's opinion in Espinoza. This court can invoke history to correct what it views as a present injustice, but it all depends on the court actually determining what that injustice is and what it looks like. It is a judgment call. And Justice Alito's decision in Espinoza is not the only place where we've seen this. In 2019, in a shadow docket decision entitled Box versus Planned Parenthood of Indiana and Kentucky, Justice Thomas, in a separate concurrence, did exactly the same thing, crafting a narrative in which he grafted the history of the eugenics movement of the 1920s to the history of abortion, on the ground that eliminating abortion rights was a necessary corrective to what he viewed as an effort to deracinate the Black community in the present day. This court is happy to cherry-pick history, but only when that history will serve the outcomes it favors. And again, when it chooses to identify the history to which it subscribes, it elides the degree to which there have been other voices speaking up in that history, objecting to the history that the court is favoring. And it also elides the fact that there are moments in our constitutional history when our jurisprudence has actually reflected the voices of the people. And Professor Siegel's work on this point, again, is instructive. As she's observed, women did not explicitly feature in constitutional text until 1920 and the 19th Amendment. Let that sink in. To the extent that equal protection doctrine in the 14th Amendment includes prohibitions on sex-based discrimination, that has largely been a product of the interaction between demos prudence, social movements, and the court's jurisprudence. The people demanding women's equal citizenship in the streets, and that vision being reflected and then subsequently enshrined at 1 First Street in the court's interpretation of the Equal Protection Clause. Now, it is perhaps not a coincidence that the interplay between the courts and the demos on women's rights occurred largely in the 1970s. The emergence of originalism as a methodological and ideological project predictably emerges in the 1980s as a concerted effort to correct the earlier excesses of the court. Despite Professor Alvaré's insistence that swaths of the public, then as now, oppose the prospect of abortion, our own understanding of the demos makes clear how contested and contestable that assertion actually is. We know as an empirical fact that 70% of Americans believe that the Constitution should contain some right to terminate a pregnancy. She's correct. Americans differ widely on what the nature and scope and substance of that right might look like. But when asked, an overwhelming majority of Americans say that this is not a decision that should be made by the state. And recent elections bear that out. Professor Alvaré notes that I hold up Kansas as a model state. That is too generous. I do not. I do not. But what I will say is that in Kansas in August, we saw an election where in that ruby red conservative state, the voters were allowed to go to the ballot box to register whether or not the state could rescind judicially required protections for reproductive rights. And Kansas voted to maintain those protections. 3 days later in Indiana, the Indiana legislature passed one of the most restrictive abortion laws in the country. Kansas and Indiana are not markedly different in their composition of their electorate. What made the difference between Kansas and Indiana in August? Well, one thing, which again is part of my argument, which I detail in the paper that Professor Alvaré elides, is that in Kansas, the vote on abortion was a voter referendum. The voters actually got to go to the ballot box and directly register their preferences for or against reproductive rights. In Indiana, the decision to enact that restrictive state law was a product of representative government, the legislature, which meant that individual legislators in Indiana cast their votes for and against that law. Now, it's true, I cannot link the prospect of gerrymandering racial or partisan, to pro-life outcomes, but I do have this proof. When Kansas got to go to the voting booth and decide for themselves whether they would keep or discard protections for reproductive rights, Kansans overwhelmingly voted to preserve them. By contrast, in Indiana, a state where I think there is clear empirical evidence of partisan gerrymandering, when the state legislature got to decide whether or not to maintain protections for reproductive rights or to discard them in one of the most restrictive laws on record, the outcome was entirely different. Now, I don't have empirical proof, but I do have that, and it seems salient. And again, this kind of realpolitik is likely not lost on this court, a court that, for better or worse, depends on the public understanding its decisions as legitimate for its own legitimacy. The Dobbs decision, perhaps more than any other decision in recent years, has called the court's legitimacy into question. And perhaps that is why, even as it insists on a selective history that shackles us to a past where women and people of color were objects to be governed, not as rightful participants in a project of self-governance, this court insists that the history would have it no other way. The appeal to history is an appeal to legitimacy without acknowledging the way in which our history is complicated, complex, nuanced, and deserving of an understanding of that in the court's disposition of these cases that impact not only constitutional law and the bodies engendered within, but all of us as well. Thank you.